recording.
Welcome, folks. I'm going to call this Board of Adjustment meeting, May 2nd, 2023, to order. Agenda calls for the approval of the minutes. First item, I have a motion.
Motion to approve.
Motion to approve, a second.
Second.
Have a second, all in favor?
Aye.
Unanimous. Is there any old business? There's no old business? We're going to new business. Mr. Eade, you want to introduce us to the?
Yes, sir. Good morning, Mr. Chairman and board members. This first item is a variance application, and the applicant appears to be Mr. William and Miss Lynn Messenger, and I hope I'm pronouncing that correctly. They here?
I don't believe they're here now. This is, so I'll go ahead and jump in on this then. The applicants were notified that there will only be 4 Board of Adjustment members, as a variance requires a 4/5 majority. They requested that this public hearing be moved to such time that there can be a full board to consider their application.
So the next one is, both of them, now the one?
The second one's here.
Oh, I misunderstood you. Well, second matter, Mr. Chair.
We'll re-advertise that and get with y'all on some dates for when we can have that hearing as well.
And that, I asked Mr. Kirkland yesterday if he would contact the, there's 2 variances on this agenda, applicants, to see if they wanted to postpone the hearing due to the fact that we understood there was only going to be 4 members, and as we all know, a variance requires a 4/5 vote. Even a 3/4 vote wouldn't be enough, so.
And Mr. Eads,
essentially-
if I could just note for the record, Mr. Hardy had indicated that he couldn't be present today. And yesterday, the one remaining alternate that we had resigned from the board.
Okay.
So we were advertising for alternates already anyway.
Right,
So
okay.
that's where we are.
So, but the second item on the agenda for new business is a variance application that was filed by Mr. David Pittman. Is Mr. Pittman here? Mr. Pittman, you understand that to obtain a variance, you have to get a 4/5 vote of the board, and that today we only have 4 members, so you would have to have a unanimous vote. I've already waited 2 months for this. Yes, sir. Well, I'm just, you're entitled, and until your variance is heard and ruled upon, enforcement action is stayed, or under the law we call it tolled. If, the same opportunity that the first applicant took us up on, if you want to continue this until we have a 5-member board. When would the next meeting be? I'll have to defer to Ms. Stites on that.
We would have to check, we'd have to poll the board. It would probably have to be at least a month out to be able to advertise.
So what essentially happens from the time you applied until the time it's ruled upon is the town puts a pause on whatever enforcement action. And I just want to get it on the record that you've been advised that if you choose to proceed today, you're going to have to get a unanimous vote since we only have 4 members. You understand that, sir? Okay, and do you wish to proceed with that understanding? Ms. Stites, will you let the record reflect Mr. Pittman?
Yes, sir.
Acknowledged only 4 members and wishes to proceed. All right, a variance, as the board knows, is a request to vary from a section of the, or sections of the town's code of ordinances. It is a quasi-judicial hearing, which means it's going to be conducted somewhat like a court hearing, and the applicant, Mr. Pittman, is entitled to a fair and impartial decision-making body. So before we get started on additional procedural instruction, let me ask the board as a whole the following questions. Does any member of the board have a financial interest in the subject matter of Mr. Pittman's variance application? Has any, and Ms. Stites, if you'll note that that was a negative response. Has any member of the board made a site visit to this property, which is located at, looks like, is it 71 or 2100?
7100.
7100 East Shot Drive. I know you may know where that is because it's not like we're in Chicago. You may have driven by it. But my question is pertaining to, has anyone made a site visit to look at this property for purposes of assessing this variance application? Right. Has anyone had any conversations with Mr. Pittman or someone acting on Mr. Pittman's behalf about this variance application outside of this hearing? Has anyone had any conversations with staff about this variance application outside of this hearing? Does anyone have a close business, family, or social relationship with Mr. Pittman? Right? Does anyone have, for whatever reason, a fixed opinion on this variance application that would preclude you from basing your vote today solely on the competent, substantial, and material evidence we hear during this hearing? Okay. Since this is quasi judicial, Mr. Chairman, we will have all witnesses who wish to provide testimony sworn in. Those witnesses will be subject to cross-examination from other parties with standing as well as to questions from the board. We will proceed first with staff to present the matter. I believe Mr. Kirkland's going to do that. He will be subject to cross and questions from the board. We will then hear from Mr. Pittman and whatever witnesses Mr. Pittman intends to bring forth. At the conclusion of the evidentiary portion of the hearing, we will start our deliberations. Again, the burden of proof is on the applicant. He must meet the 4 criteria, and you can find that criteria in your agenda packet, and we'll talk about more in discussions or deliberations. And I believe that's all I have at this point, unless there's any questions of the board. And if there are not any questions, I would ask all those who wish to provide testimony to come forth and be sworn in.
You'll go over to the clerk, please.
And I'm gonna back up a little bit because I'm getting over. You can just raise your hand. Okay. Do you solemnly swear that the testimony you give to the Board of Adjustment during this hearing shall be the truth, the whole truth, and nothing but the truth to help you God? Go ahead. Not anybody yet, because when you are providing testimony, you're turning over. Okay.
Ready for me?
Yes, sir.
Morning, board members. I'll skip through this first one since they asked to be continued. So your second agenda item, the first one to actually be heard, is an application for a variance for the side setback for accessory structures. Property is located at 7100 East Yacht Drive. We'll go through those variance standards Mr. Eads talked about very briefly. Variances can be granted when the board finds that an unnecessary hardship would result from carrying out a strict letter of the zoning ordinance. They have to meet 4 standings. The board must find that the unnecessary hardship would result from the strict application of the regulation. It's not necessary in the absence of a variance to prove that no reasonable use of the property can be made. The hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstance, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. The hardship did not result from actions taken by the applicant or the property owner. The act of purchasing a property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship. And then finally, that the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. As the town attorney just mentioned to you, a variance requires a concurring 4/5 of the board in the affirmative in order to be granted. The applicant in this instance has requested a variance to the side setback requirement for accessory structures. As I mentioned, it's at 7100 East Yacht Drive, tax parcel ID 236-OA01001. Property is zoned R6MH and is subject to an 8-foot side setback. That should say for accessory structures, I apologize. There's a typo in your staff report that says the applicant's seeking a 3-foot variance. The variance being requested is 5.5 feet. I apologize for that, and I'd ask that the staff report be amended when it's offered into evidence for that.
Can you tell us what page that is on, in,
Page 20 of your application, the last sentence of the first paragraph under subject summary.
my page 20. Can you show me where you are? Just, I want to make sure the board knows where we are. My page 20 looks like that.
Yes. First paragraph.
Oh, I thought you said last paragraph, okay.
Last sentence of the first paragraph.
All right, Mr. Chairman and board members, do you see on page 20, very first paragraph, last sentence, where it reads 3 foot as printed?
Yes.
Mr. Kirkland says that's a typo and that should be 5 feet,
5.5 feet.
5.5.
5.5 feet.
Thank you. Go ahead, Mr. Kirkland.
Thank you. Here's an aerial photograph of the property as well as the zoning overlay. As you can see, most of the property around it is also similarly zoned R6 MH. This property backs up to some OS, which is an open space zoning. And then further out is the intercoastal waterway as you go to the north there. And finally, we have the applicant's diagram. Sorry, we don't have a laser pointer with this. The subject accessory structure is in the top right corner. It says 3 foot on this, but in the applicant's materials, it says 2.5 feet. So that would be a 5.5 foot variance from the 8. Would be the requested variance there. I'd be happy to try to answer any questions you might have.
Before we have questions from the board, Mr. Kirkland, as I read the agenda packet, pages 20 through 40 pertain to this particular variance application. Is that right?
That's correct.
Would you like to offer that into evidence as Exhibit A?
I would, as amended.
Okay. Mr. Pittman, do you have any objections? I don't know if you've seen the board agenda packet, but pages 20 through 40 are materials that pertain to your application. And they're double-sided pages. That one's 41, if you want to look through that.
Oh, yes.
Okay. Do you have any objections to the board receiving these pages into evidence related to your variance application as Exhibit A? No? Okay. Let the record reflect, there are no objections, and Mr. Chairman, I recommend we receive pages 20 through 40 of the agenda packet into evidence as Exhibit A.
Let be entered.
Mr. Pittman, do you have any cross-examination questions of Mr. Kirkland? No, the only thing. You'll have a chance to put on your case in just a minute, but right now, you have an opportunity to ask him questions about what he just said, everything he just said.
I'm asking for the variance, this 3 foot variance.
Now, he contends it's 5.5 feet. Do you want to ask him questions about how he arrived at that number? I'm not trying to make your case for you.
I wrote it wrong on the thing. It could be 3 foot versus 5 foot versus 3 foot.
All right, Mr. Kirkland, has staff taken any physical measurements to determine how far the encroachment is?
We have not. The applicant's information found on page 26 and 27 is asking for notes that they would like to move the setback from 8 feet to 2.5 feet. That would result in a 5.5 foot variance. When you take 2.5 from 8, you are left with 5.5. So the actual variance you would be granting would be for 5.5 feet out of that 8 foot. Certainly the applicant can request something different if that's. But the variance, should the board grant a variance, it should be for the actual distance from the property line that they need in order to be in compliance.
Right, and I think we can, Mr. Pittman, when you come up, I think we can ask you some questions. Do you have any additional questions for Mr. Kirkland? Mr. Chairman or board members, do you have any questions of Mr. Kirkland? All right, Mr. Kirkland, thank you.
Thank you.
All right, Mr. Pittman, here's your opportunity to put on your evidence. You realize it's your burden of proof to prove that your application meets the 4 criteria described by Mr. Kirkland, and I believe it's also in the variance application. You understand that? Yes, sir. And for the record, if you will, the minutes of these proceedings, if you would just identify yourself before you start putting on your evidence.
Yeah, I'm Dave Pittman, and we used to live here,
Would you give your address too, please?
7100 East Yacht is our address. We used to live on southeast 16th, or southeast 12th Street, and our house got struck by lightning and burned to the ground, and we ended up buying this house. And we had our other house all set, so when we bought this house, we wanted to, we owned Island Joe Coffee Shop. We just sold it 2 months ago, and we're retiring. And we wanted to set this house up as our retirement house, and I'm asking for the variance for a 10-foot section so I can put a gazebo up for an outdoor kitchen. It's basically 4 posts with a roof on it and a back side. The front is open and the sides are open. That's what I'm asking for, just a 10-foot section where I measured, he said the 5.5 foot. Well, I had measured from the fence. We moved, the fence is 6 inches from the property line, so it's actually 3 foot off the property line, and asking for it to be a 5-foot variance then. And if I go too far, if I have to move it to the 8 foot, I can't put it up because it'll be in the swimming pool. I've spent over $100,000 in the last year on this house, trying to make it what we used to have at our other house and setting everything up. And I don't want to encroach or interfere on anybody. My wife and I, we live there. We don't bother anybody. And this can't be seen. It doesn't interfere with anybody's property or anything whatsoever. And that's pretty much what we're asking for.
Mr. Chairman? Yes. Are there any adjacent property owners here today in opposition of this?
We'll hear from that momentarily.
Okay, I just thought that'd be good mentioning at this point. My other question is, my survey on page 31 shows a proposed pool. So this survey is out of date?
Yeah, the pool's in. It's all been,
And that was done with all your permits?
yes, everything was
Thank
perfect. Yes, sir.
That's-
Signed off on everything. Yep,
Has the gazebo been started?
yes.
Was it permitted?
No, because I was under the impression that I didn't need a permit because it was smaller than a 10 by 12. It was 8 by 10. And I since found out that it needed to be permitted, which I have the application for the permit. And I wasn't aware that a gazebo needed, because I know you can go to Big Lots or Home Depot and you can buy a gazebo right off of their floor. And I've since found out if you buy one of them gazebos, you have to have a permit to put that thing up on your property. And I didn't know that. And the only reason I didn't buy one of them versus building one, I wanted to make sure it was secure because I was afraid that if we have a storm or high winds, that I put the gazebo up, it'd be gone with the wind and tear it all up. So.
I just want to point out to the board that the applicant did provide some pictures. They're included in your agenda packet. Are those the pictures that you provided of the gazebo as it stands?
What's that?
Are these the pictures that you provided? Are those of your gazebo in this instance? Okay. So the pictures in your packet of a gazebo are of the applicant's?
It's on page 35.
Yes, it appears to start on page 35, 36, and 37, and 38.
Also some pictures in there of the completed one that the guy had built on another property somewhere. I think it was in St. James.
And those are pages 32, 33, and 34 of your agenda packet.
Like I said, I'm just asking, it's a 10-foot space. It's already concreted. The concrete from the pool pad is there. There's a foot space between the concrete and the fence where there's gravel for drainage and everything like that as need be, so.
Mr. Chairman, if I may,
Yes.
Mr. Pittman, do you have a copy of the agenda packet up there? It's double-sided, but if you'll turn to page 27. When you're there, sir. Is this something that you wrote and submitted in connection with your variance application? And my 27 begins, "I would like to request a change to the setback on my lot." Do you see that?
Yes,
Are these your words, or?
Yes, sir.
Okay. And where I'm going, or where I'm trying to go, I want to make sure I understand, or the board at least understands, the extent of the encroachment variance you're requesting. So if you'll read that, it looks like it's the third sentence. "I would like to move the setback from 8 foot to 2.6 foot."
yeah, it's actually from the 3 foot, because I didn't count the 6 inches that the fence is off of the property line. When I did, it's actually 2.5 foot from the fence line.
I think it's important that we're clear on what you're seeking. So if the setback is 8 feet, correct, Mr. Kirkland?
That's correct.
How close to the property line is the extreme portion of the structure, the outerward,
It would be 3 foot from the property line.
so 3 minus 8 is 5.
Yeah, it'd be 5, yeah.
So you're looking for a 5-foot encroachment?
Yes.
Variance?
Yes.
Again, I don't want to put words in your mouth, I just want them to know
Yes,
what you're
yeah.
asking. Okay.
I get confused when I'm actually asking if this is the property line, this is 3 foot in, and I guess that would be, the encroachment then would be 5 foot.
Okay, and I just want to make sure we're clear on that, so, and again, that's how I'm interpreting what you're saying, but this is your application, so I'm not trying to put words in your mouth.
No, that's,
But you want to build up to 3 foot close to the property line?
yes.
Okay,
There's nothing else there. There's no utilities back there. All the utilities are in the front. The back of the property goes into the intercoastal waterway. So there's nothing that it bothers in any way, shape, or form.
and when you began construction of this structure, at that point, I think your testimony is you had not obtained any permits?
No,
Had you talked to anyone and town staff as to whether you needed a permit?
I looked online and it said in Brunswick County that anything over a 10 by 12 you needed a permit for, but anything smaller than that you did not need a permit for. And I since found out that Oak Island requires a building permit, I think, for everything.
So your pre-construction research, you looked at the Brunswick County Code,
Yes,
not at the Town of Oak Island Code?
I didn't see anything on the town of,
Okay. And did you call anyone at the Town of Oak Island prior to construction?
no.
Okay. All right.
It was not my intent to
I understand. I just,
go around the permitting or anything like that. I've had a pool put in, I had a wall put in on the canal, on the intercoastal. I had my house underneath completely built up, what you call enclosed, the bottom level enclosed. This is all permitted, the fence, the pool, the concrete, everything was all permitted.
were any of the contractors that pulled those permits, was the same contractor that constructed the gazebo did he or she or it pull any of the other permits you
No,
just referenced?
no.
It's a completely separate contractor?
Separate person whatsoever. He's just a one-man show.
Okay. Thank you. Mr. Pittman, Mr. Chairman, any other questions from the board?
Yes, as the fence is exactly on the, dead set on the property line, the fence, the black iron fence.
No, I don't think that's the case.
That,
Fence is 6 inches off the property line at that point.
I think that should be taken into consideration.
Yeah, when I first measured it, that's why it says 2.5. And then somebody said, well, you got to measure from the property line. That's why I said.
This can go right up.
if there are any other questions for Mr. Pittman from the board?
Any other board members have a question for the applicant?
Well, I want to go back to page 20, where it said 3 foot. I marked it out and put 5.5 foot. What is accurate and correct there?
According to the applicant, it would be 5. The applicant's material indicated 5.5. His testimony today has requested a 5-foot variance.
So 5.5, he's gonna be 3 foot off the property line. So we marked that correctly at 5.5.
It should just be 5, no half, just 5.
Wow.
Yes,
That's
sir.
what he's seeking. I don't think staff's taken any measurements, so we're relying on the applicant's math, if you will. Okay. So would you agree that you're seeking a 5-foot
Right.
variance?
Yes.
Encroachment, okay. All right, if there are no more questions from the board, Mr. Chairman, it appears that at least one, if not 2 other people were sworn in.
Yes,
If they can provide testimony, but if they have standing, they would also be entitled to cross-examine Mr. Pittman. So I would ask whoever, Madam Clerk, was sworn in, somebody, whoever, come on up, ma'am. And Mr. Pittman, if you'll just have a seat there for a moment.
You need this back or you?
Oh, you can just leave it up there if you want to for the next person.
if you will, state your name and address for the record, please.
Yes, good morning. My name is Angela Warren. I live next door at 7102 East Yacht Drive.
When you say next door, is your property,
I own properties 4B and 4D on the diagram on the screen.
so would the requested encroachment be towards your property?
Yes, sir.
Okay.
And a couple of things I would like to,
Ma'am,
oh,
one
sorry.
second.
Go ahead.
Mr. Chairman, given the proximity of Ms. Warren's property and the fact that the encroachment is towards her property, I would request that we find that she does have standing
Yes,
as an adjacent property owner. And since she does have standing, she's entitled to ask Mr. Pittman any cross-examination questions if she'd like. Would you like to ask any questions?
Questions per se, but I can answer some of the questions you've already asked
Sure,
him.
okay. Well, we're going to follow a certain procedure here, so let me wrap up with Mr. Pittman's case. Did anyone else, was anyone else sworn in? Okay. So, Mr. Warren, if you'll have a seat just for a moment, we'll let Mr. Pittman finish, and then you'll be able to come up and provide testimony. Thank you, Ms. Warren. Mr. Pittman, you want to come up? Do you have any additional evidence you'd like to offer to the board at this time?
No.
You will have an opportunity to cross-examine Ms. Warren and anyone else who may testify as well. But the procedure, we're going staff, you, then other parties. But you'll have the same opportunity to ask any other witness questions as we've already done so far. Okay?
Okay.
All right, thank you, Mr. Pittman. Ms. Warren? Come on up. Madam Clerk, do you need her to identify herself again?
No, sir.
Okay. All right, Ms. Warren, there's been no objection to standing, so at this point in the proceedings, you can provide whatever testimony you feel is relevant to this variance application.
Yes, sir. I brought some photos today to better describe to you all or to show you all what the property looked like at the time that Mr. Pittman purchased the property in 2021. I also brought you some photos of what Mr. Pittman's outdoor kitchen gazebo looks like from my property, standing up from my point of view. May I approach and pass those out, or to whom must I give those?
Yes, ma'am. Actually, hand them to me. Here's what I'm going to do. I'm going to show them to Mr. Pittman first and see if he has any objections, and then we'll go from there.
That's 7 copies there.
Not really, but that's okay. Okay.
Yes, there are 6 total.
Mr. Chairman, Ms. Warren would like to offer into evidence 6 photographs that are stapled together. I recommend that we mark that as Exhibit B. Mr. Pittman, do you have any objections to the board receiving?
There's no objections from the applicant. We can mark them.
All right, and I'll hand those down, sir, or actually, I'll pass them out.
Sir.
Ms. Warren, do you have your own copy, or do you need a copy? Okay, let's do this. I'm gonna number them, so that way we know which, sequentially, so the first page obviously be 1. My handwriting's worse than a doctor, but hopefully you'll be able to read it. And for the benefit of Madam Clerk in the record, Ms. Pittman, I would ask that you identify what page number you're on as you go through these pictures.
Absolutely.
I'm sorry, I called you Ms. Pittman, Ms. Warren.
Thank you. So the first photograph is an aerial shot. This is actually from the MLS site in which the purchase, or the house was put up for a sale. And at the time Mr. Pittman bought it was December 12th, I believe, of 2021. The next shot is also from the MLS site. It too gives you a vantage point of where this outdoor kitchen gazebo is placed from the other photos you've seen, as it shows both my side of the yard there, my home, my yard touching his, and it shows the state of the backyard at that time. That's page number 2.
Ms. Warren, is your home the home that's bluish in color, grayish?
Yes, sir,
color?
that is
Okay.
my home. That's 7102 East Yacht.
Thank you, ma'am.
Should we number these as we go along in case we refer back?
Sure, I mean, I just did it,
1 through 6.
yeah, I just did it,
Numbered mine 1 through 6, is there?
yeah. And we were just referring to page 2, the house to the left. In bluish, grayish with the shadow there is Ms.
And
Warren's
to
home.
back up to page 1, the house on the top would be the house in question.
Yes, the house on top is Mr. Pittman's home.
Yes.
And property, and the house next to that is my home. So page 3 is a current picture of what Mr. Pittman's home looks like today. That photo was taken yesterday, and it does show the outdoor kitchen being there right off of my home. The question was asked, how many feet away from the property line is this structure? The rear of this structure is actually 32 inches off of the property line from my home. That is the back side of this outdoor kitchen.
Just for clarification, Ms. Warren, how did you arrive at the 32 inches? Have you had the property
A tape
line?
measure and going out and measuring from the back of the tape, bringing the back of the tape measure to the back of the building and pulling it over. It's 32 inches from the line. The property lines are marked between our 2 homes and have been since the day Mr. Pittman purchased them.
That was my next question. There's been a survey out there showing the boundary line.
The stakes are still there from where I originally purchased the home.
Okay, thank you, ma'am.
So the fourth photo is standing off of my back porch, looking down at their outdoor kitchen. You can see from this photo how close it is to both their home and my home. Similar for the purposes of page 5. This one is taken from inside of my home. That is right next to where my sofa sits. And then the final is to give you a view there, page 6, of standing right at the property line. You can actually see one of the markers there just on the other side of the plant, almost dead center of the photograph.
And it's your testimony that if you drew a straight line from that stake to I'm assuming there's a stake further up that you used to determine the line.
If you look in your packet that the town sent us, so there's a color photograph of the two homes and the property lines, you can see there, that is the stake that's kind of in the middle. And I
So-
can be more specific if you need, but
So when you say, did you say 32 inches or 32 and
it's
a half?
32 inches away from the property line.
And are you referring to, if you'll look at the wooden structure inside the gate on page 6?
Page 6, yes, sir, I am. Flipping back. Yes, sir. I am talking about if you take a tape measure, you place it on the rear of that wooden building, entire wall of wood, and you come back, that is from where that stake is. That's what I'm talking about. That's the property line.
So you're saying that the wall of that wooden structure, the exterior closest to your property, from your measurements, is 32 inches from the boundary line?
Yes, sir, that is what my words are.
Okay, thank you, ma'am. You can proceed, Ms. Warren.
Okay.
Sorry to interrupt
So
you.
I do want to thank you all for hearing my perspective today and hearing my concerns about this variance hearing. And first, I would ask you if running out of room in your backyard constitutes a level of hardship. And does this hardship afford you the ability to encroach on the 8-foot setback set by the town and on your neighbors? In the past, the board has deemed hardship as appropriate for persons who have suffered some type of accident or who are unable to gain access, for example, into their home, needing an elevator, needing a ramp, etc., not an outdoor kitchen. My next point of concern is I'd ask you to consider the situation is of Mr. Pittman's making, as per the 4 criteria. Mr. Pittman purchased this home, as I mentioned, on December 12th of 2021. And as I've shown in my packet of photos, he started with a blank slate for a backyard. To start, Mr. Pittman built a large deck and staircase extending off the rear of the porch. He then proceeded to build a seawall. He installed a pool. He built retaining wall around that pool. And then Mr. Pittman had a large concrete pad and bib poured onto the pool up to the property lines. Next, he added an aluminum fence on the back of the yard, and then followed in by cutting in French doors into the rear section of his home, the storage unit underneath, and then finally, he enclosed the entire bottom portion of the dwelling, some of which he's mentioned here today. Now that he's used up all of the space available to him, he wants a variance for an 8x10 outdoor kitchen that sits approximately 2 feet off the property line and right between our 2 homes. My next concern is very troubling to me and my family as it relates to fire safety. The size and location of the outdoor kitchen or gazebo creates a fire bridge between the 2 properties. Fire could easily travel or blow from his property to mine or vice versa, as it's currently positioned so close between the 2 homes. Finally, I'd ask you to consider the hardship this encroachment presents to me and my family. I will most likely, or if this variance is approved, it could pose hardship as an issue for me selling my home. I will most likely have to explain why a modern home built less than 5 years ago, where we have a setback encroachment, and it's not a grandfathered building. This isn't a building that existed prior to what happened in the backyards of the building of these two properties. At the time the two houses were built, this 8-foot setback existed in this section or zone of Oak Island. The builder had to adhere to the 8-foot setback to build the two homes as well. And with a thoughtful design, proper sizes and locations, Mr. Pittman could have fit all of the amenities in the space available without encroaching or putting his neighbors at risk. As I said, I've provided additional photos to give you a perspective of what this looks like from my home and my concerns. Thank you again for hearing them, and please let me know what additional questions I may answer.
Okay. Ms. Warren, one moment, please. Mr. Pittman, you have a right to cross-examine, ask questions about what Ms. Warren just testified. I'm going to give you that opportunity now. Would you like a copy of Exhibit B? Okay. Would you like to ask Ms. Warren any questions, sir? Okay. Any questions of Ms. Warren from the board? Okay. Ms. Warren, just to get to the chase of it, I take it based on your presentation, or I shouldn't assume, but I'll just ask the question. Do you object to the issuance of this variance?
Do I object to what?
To the board issuing a variance based on what you just testified to?
If I understand your question, yes, I object to you granting this variance. Is that the question?
Yes, ma'am.
Okay.
Yes, ma'am. All right, if there are no questions of Ms. Warren,
Counselor, just one quick question. Is that the bona fide marker for the boundary line? Could you ask,
I'll ask staff.
planner, yeah.
According to
Is that
Ms.
in fact the property line stake? Because stakes can be kind of iffy sometimes.
One second.
I have a problem with the survey, those are the stakes.
Okay, well, before, okay, hold on. He's asking about that stake.
I'm not a licensed surveyor. I couldn't identify that one way or another. You need an actual registered surveyor to go out and make that determination.
Saying you think that's unreliable.
I'm saying I can't make that determination for the board.
I'm gonna ask Mr. Pittman, could you come up, please? Ms. Warren, you can have a seat if you like. The question, I'm on page 6, Ms. Stites, of Exhibit B.
Thank you.
Is that a survey stake?
Yes.
Okay. Could you just take, I'm gonna ask you that officially for the minutes, Mr. Pittman. Mr. Pittman, you have in front of you Exhibit B, turn to page 6. If you'll look about middle of the page, you'll see what appears to be some sort of survey spike. Is that the survey indicator that you had performed?
Yes,
So do you believe, based on your
yes.
review,
There's
that's
a
an
stake
accurate?
there with the pin, with the plastic tie going from the pin to the top of the stake.
Okay, so that's an accurate depiction of the stake that was
Yes.
inserted by your surveyor?
Yes.
All right. Does that answer your question, sir?
Yeah, that is the property line.
Yes, sir. Okay. Thank you, Mr. Pittman. Anyone else in the audience like to provide testimony?
Can I say something?
Yes, sir. I'm gonna give you a chance to do kind of a summation, but you're welcome to now if you'd like.
When we purchased the property on Yacht Drive, I went to the neighbors and I told them, because I had to have them sign off on the CAMA permit, the CAMA minor permit, to have the retaining wall built where the intercoastal comes up. And they signed off on that. And at that time, I told them, I said, this is what we intend to do at our house. And one of the reasons what I did was I built the deck on the back because of the fact that when those houses were built, there's only one way in and out of those houses. And having gone through a fire and had my house burned down, if I would only had one way out of my house on Southeast 12th Street, I wouldn't be here today because of only one entrance. So the reason I put the deck on the back was with stairs, so that we would have another way out of our house. And I think I've done everything possibly to make our yard as pretty as, and nice as possibly could be. And when I went to them, I said, if there's any issues, please come to me and I'll make sure that they're resolved. And and I don't want to get into a match of he said, she said, but there's just, the things have happened, and this is just, to me, spite. She ran off the concrete guy that was putting the concrete guy in, cussed the tree, I had some trees cut down on my property. And I will admit, I cut a tree down that was on the right-of-way, but the guy told me the tree was dying. But I got in trouble for that, but that's been taken care of. But this woman has talked to me like I have never, ever been talked to in my life. And totally uncalled for, in my opinion. It's cost me thousands of dollars. The concrete guy took my money and run. He says, I'm not coming back there. And I have to go after him now to get my money back from the concrete. And besides that, these people are building a new house right down the street and are moving away. And be one thing too, but they're never out there on the outside of that property or outside of the house. So that's all I really have to say. Thank you.
All right, just briefly, Mr. Pittman, and thank you for not allowing this to digress into things that aren't relevant. Ms. Warren, do you have any cross-examination based on that testimony, solely based on that testimony?
Based on that?
Yes, ma'am.
And related to this.
Yes, ma'am. And I would request, which you've done so far, that you, let's not allow this to digress. Let's
Totally agree.
stick it to the criteria. It's been professional so far, and I thank you both for that. Go ahead, ma'am.
So, Mr. Pittman, when you came over and asked and told us about what you were going to be doing with your property, was my one request to you to please not encroach on my property during this process?
Well, hold
You
on.
are encroaching on my
Let's
property.
not converse between each
Hold
other,
on.
if you will.
Is your question, Ms. Warren, to Mr. Pittman, that when you all had a discussion at some point, you asked him not to encroach upon your property?
I did. When he came to me and he asked us to sign off on the seawall, everything was very cordial. And the one thing that I left him with, I showed him where the property lines were. I gave him a copy of my property survey as well. And the one thing that I asked of him was to please not encroach on my property and create a situation that I would need to have to rectify as I sold my property.
Mr. Pittman, if you could come back up, and Ms. Warren, if you'll just, there's a chair behind you. Do you recall a conversation as Ms. Warren just described about?
I don't recall that, but to answer that question, I've never encroached on her property.
Well, that was going to be my next question to you, but what you're seeking to do here today is to encroach into the setback, not
Right,
to encroach.
has nothing to do with her property.
Okay. And you don't recall one way or the other whether you had that conversation with Ms.
Only
Warren?
like I said, we had the conversation. I told them, I said, if there's any issues whatsoever with anybody doing any of their jobs, I would appreciate you coming to me and I will make sure that they're addressed. And that's never, ever, ever happened.
Okay, thank you, Mr. Pittman. And just for the record, obviously, Ms. Warren, as adjacent property owner, has the right to come in here and express whatever her opinion may be regarding this variance application. Ms. Warren, do you have anything additional?
No, sir.
Okay, thank you, ma'am. Anyone else in the audience, whether you've been sworn in or not, wish to provide testimony today? Madam Clerk, let the record reflect no one has indicated they want to testify. Mr. Chairman, at this point, Mr. Pittman, since you're the applicant, if you want to say a summary of it all, I'll let you, give you one more opportunity. And I would ask you to keep it relevant to the criteria that you
The
have.
only thing I have to say is I have done nothing but to try to improve my property. My backyard is gorgeous. And I've done everything possible to enhance our house, as I did on Southeast 12th Street also. And I try to take care of everything I own as best as I possibly can. And that's just the way I am. I tried to keep it as nice as possible. And that's why I did what I did. It had nothing to do with these neighbors or any neighbors or anything like that. Just the way we are, we try to keep our stuff and our property as nice as possible.
Thank you, sir. Thank you. Mr. Chairman, historically, I would close the evidentiary portion of the hearing, but I have found that oftentimes during deliberations, you may want to ask a clarifying question of either staff. So what we'll do is we'll go into deliberations and just hold the evidentiary portion open, and we'll close it all once the board reaches a decision.
Very well.
Okay. You can handle your deliberations in several ways. As we talked about earlier, there are 4 criteria. You can take that have to be met, and all 4 of you must agree today, since it requires a 4/5 vote.
Typically, we take those in order, 1 through 4. If the board pleases, we'll do that again.
Works for me. I'm not
Somebody
on the
want
board,
to address item number 1? We'll take number 1.
Page. What page? 1 through 4.
And I'll just read it into the record.
Okay.
The first criteria is the applicant must demonstrate that there is an unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. So would a strict application of this 8-foot setback result in a unnecessary hardship?
I don't see it personally, I don't see it as a hardship, inconvenience, yes, but a hardship, I don't believe it comes to that level.
I agree.
Any other comment on that?
I agree.
I'm inclined to agree with you.
Second criteria,
Yeah, well, I mean, they have to meet all 4, but we can go through.
Yeah, let's just-
Well, if you don't find that there's a hardship, then you, by my reading, the second criteria is premised on there being a hardship, because it states that results from conditions that are peculiar to the property. So. That's up to Mr. Chairman.
I think after 1 is shot down, the rest is a moot point. They all have to be met.
I believe Mr. Pittman would like opportunity to say something, and that's. Oh, sir, wait. Wait. Sir. I'll just go ahead and chime in here. That's the ordinance language, and that's what you have to prove, is that there is a unnecessary hardship. But if you want to say anything else, I'll defer to Mr. Chairman, as chair, if he would like to allow Mr. Pittman to say anything else.
We're bound by state guidelines, state statute really, that we have to adhere to these 4 standards. We don't have any leeway to speak of. And if we can't find these as absolute, we really can't vary from them. So we have no recourse. And the very first one, I don't see a clear way of getting around that one. The second one and third one, they really get you deeper in the hole on that. The hardship did not result from the actions taken by the applicant. I mean, if there is a hardship, you caused it. So, you know, that digs deeper into the hole. So I think we're at a point right now where I think the board can vote on this. Counselor?
Yeah, Mr. Chairman, if there is a motion to deny, I think the point you just made is important to make, that if the rest of the board agrees with you, that if there was a hardship, that hardship, if it's the board's contention, as you just said, that hardship was self-created. So
Yes.
I would ask you to be mindful of that, or whoever makes a motion either way. Thank you.
So if the board feels ready, I'll entertain a motion to deny or approve a variance.
Being they haven't been able to to show a hardship, I say would be denied. Make a
Have
motion.
a motion to deny. Do I have a second?
I'll
I'm
second.
compelled
Have a
to,
second.
Yep, yep.
All in favor? Unanimous. We have a unanimous vote to deny the variance. If staff will proceed with that.
Yes, sir. Thank you, Mr. Chairman. Mr. Pittman, thank you for your time today and the way you conducted yourself. You heard the board's vote. We'll get an order to you. Ms. Warren, I thank you as well. If you'll indulge me, Mr. Chairman, let me walk down to the clerk and give her the exhibits for this.
Number 3.
Okay. Thank you.
I'm thinking I'll remember what I made much difference.
Well, you can't put, I'll tell you, man, that fire pit that close to the other house.
Whenever the board's ready to proceed, we'll move on to the next item.
We finished with the first item.
Yes, sir. Mr. Pittman, the board voted to not approve your variance. It was a unanimous vote. At this point, staff and I will reduce that decision to writing, and you will be served on that. You have certain appeal rights to the Superior Court. I'm not your lawyer, so I can't give you legal advice. But I do thank you for the way you conducted yourself today, sir, as well as Ms. Warren. And we're going to move on to the next item. Thank you, sir.
Mr. Reeves, can we get a motion to close the hearing?
Yeah, let's go ahead and motion to close the
Have a
evidentiary
motion to
hearing.
close?
Second.
Second. All in favor? We're closed.
Thank you.
All right, second item.
Yes, sir. Again, this will likewise be a quasi judicial hearing, but this is an appeal from a final staff decision.
Mr. Eads,
Yes, sir.
I don't know if I know everybody hasn't been involved with an appeal before. If you'll
I'm gonna get into Yes, sir.
Make the difference.
I sure will. As we just saw, a variance is a request to vary from a section or sections of the code. An appeal is a citizen's or a corporate entity's appeal to the Board of Adjustment because they disagree with a staff decision. The purpose of the Board Adjustment in hearing appeal is to determine whether, based on the evidence produced during this hearing that's coming up, whether the final staff decision being appealed from is consistent with the ordinance. The board can either affirm, reverse, or modify the staff's decision based on the evidence. When looking at the ordinance from which the decision was based, it's the duty of the board to ascertain the intent of the ordinance. And you do that by first looking at the plain language of the ordinance. 2, seeing if in context, something around the ordinance gives you an indicator as to the intent of the ordinance. And 3, if you give words their ordinary meaning if they're not defined in the ordinance, but we are also allowed to consult to a dictionary to see the ordinary meaning. Unlike a variance, an appeal decision only requires a majority vote. So in this case, it would be 3 out of 4. It's the applicant's burden of proof to prove through competent, substantial, and material evidence that the decision they are appealing from was an error. Like a variance, though, the applicant or appellant is entitled to a fair and impartial decision-making body, so I need to go through those questions again for this appeal. The applicant is, can you help me with that, Matt? Is it Nathan Dixon? No, I'm sorry, Andrew, Mr. Schilling? Okay. The applicant's Mr. Andrew Schilling, Schilling. The property address is 332 Northeast 41st Street here in Oak Island. So, and that's my understanding that the decision, according to the staff summary, pertains to the manner in which a fence was constructed, but I'll let staff get into that in a moment. Does anyone have a financial interest in the subject matter of this appeal? Madam Clerk, in the negative. Has anyone made a site visit to this site for the purposes of assessing this appeal? Has anyone had any ex parte discussions with the applicant or someone acting on behalf of the applicant? Has anyone had any discussions with staff regarding the subject matter of this appeal? Does anyone have a close family, business, or social relationship with the applicant? Does anyone have a fixed opinion about this appeal that would preclude them from basing their vote solely on the evidence adduced during this hearing? Okay. All right, just similar to the variance as far as procedure goes, we'll start with staff, then we will hear from the applicant. All those who wish to provide testimony must first be sworn in, and they will be subject to cross-examination as well as to questions from the board. Since this is a separate hearing and we closed the prior hearing, even though Mr. Kirkland's already been sworn in, I'll ask him to be sworn in again if you're going to present on behalf of staff. Then we will hear from the appellant, and then we will hear from any other parties. If they have standing, they'll be able to cross-examine. If they don't have standing, we may hear from them just as a witness. So unless there are any questions from the board, Mr. Chairman, I would ask all those who wish to provide testimony during this appeal to come forward and be sworn in.
Mr. Eads, if I could ask you, I noticed that my packet I printed out this morning is missing the last 10 pages. I've had issue with the copier this morning, obviously. So your packet should go to page 59. If you do not have that,
59.
yours is 59?
Mine's 59.
Okay, so it's just me, good.
Okay.
You'll come forward and be sworn in by the clerk, please.
Left hand on the Bible, raise your right hand. Back up to 90 feet drops. You solemnly swear that the testimony you provide to the Board of Adjustment for this hearing shall be the truth, the whole truth, and nothing but the truth, so help you.
All right, we'll hear from staff first.
Good morning. Click through these. So I'll introduce the item for you here. This, as Mr. Eads just mentioned, is an application for appeal. The instance here, a fence that failed an inspection due to the manner of construction. Property located at 332 Northeast 41st Street. The applicant has requested an appeal of that failed inspection for a fence. That's just mentioned the location. It's zoned R6. The applicant is appealing a staff determination that the fence does not meet the requirements of UDO section 7.8.9. That section reads that fences shall be constructed so that the finished, and in parentheses, sheathed side is oriented toward adjoining lots or the public right-of-way. Timeline on this particular issue, the town received a fence permit application on March 6th, 2023. The permit was issued on March 13th, 2023. You should have that permit information included in your agenda packet. A page outlining the ordinance and the conditions was signed upon the issuance. That page is included in what the applicant picks up when they get their permit. And that includes section 7.8.9 on that page. The fence inspection was conducted on March 22nd, 2023 by zoning technician Deidre Horn. She's here to provide testimony should you need it, as she is the staff member that made the determination. The inspection was initially passed in error and corrected the same day. That correction to fail the fence inspection noted that the fence did not meet the ordinance requirements and for the applicant to contact the planning department. You also have a copy of that inspection report included in your agenda packet. Property owner filed an appeal of determination on March 27th, 2023. Including your agenda packet are these pictures from the inspection provided by Ms. Horn. If you're facing the house, this is the left side of the house showing the exterior of the fence. This is the interior of that left side. And then by contrast, this is the exterior of the right side of the fence. I'd be happy to answer any questions. Once again, Ms. Horn is here to answer questions as well.
Mr. Chairman, I have a question, if I may.
Go ahead.
Mr. Kirkland, do any of these pictures show the violation as determined by staff that's being appealed from?
Yes, this picture.
Okay, can you, either you or Ms. Horn, can you elaborate what this picture shows? For the record, it's at the bottom, it's got,
Says left exterior on the sticker there, just to identify where that is. Mrs. Horn's determination, she can come up and testify to this as well, should the board want, was that those support structures are not the finished and sheathed side of the fence, as that does not, as the finished or sheathed side is required to face adjoining properties. This does not meet that standard of the ordinance.
and are you talking about the, as you look at the picture, the extreme left siding, it's almost abutting that chain link fence?
Yes, where you can see the horizontal cross members are, those support members are facing the exterior, that's correct.
So the determination was that side of the fence is not the finished, parentheses, sheathed side of the
Correct.
fence? Could you go to the next picture, sir? Next picture, sir. All right, and is it, well, based on your opinion as a staff member, does this picture that has right, little sticky mark on it, right, depict the finished or sheathed side of the fence facing the adjoining property?
Yes,
So that would be code compliant in your opinion?
correct,
That's the difference?
that's correct.
Okay. Would you like to offer into evidence pages 41 through 59 of the agenda packet related to this appeal as Exhibit A?
I would.
All right, Mr. Schilling, do you have any objections to the agenda packet related to this item coming into evidence? Okay, thank you. Mr. Chairman, I recommend we accept pages 41 through 59 of the agenda packet as Exhibit A without objection.
Enter.
Mr. Schilling, do you have any cross-examination questions of Mr. Kirkland? I'm sorry, you say no? Okay. Does the board have any questions of Mr. Kirkland? All right, thank you, Mr. Kirkland.
Thank you.
And I'll just, as attorney for the Board of Adjustment, I'll just call Ms. Horn up real quick.
State your name and position.
Hi, Deidre Horn, zoning tech for the town of Oak Island.
All right, thank you, Ms. Horn. It's my understanding you are the town employee that issued the violation?
Yes, sir.
Okay. Did you just hear Mr. Kirkland's testimony about the comparison between the two pictures we looked at?
Yes, sir.
Are you in agreement with Mr. Kirkland as to his interpretation of the ordinance as to the finished sheath side versus the unfinished sheath side?
Yes, sir.
Okay. Is that the basis of your violation?
Yes, sir.
Okay, thank you, ma'am. Ms. Schilling, you have any cross-examination of Ms. Horn? Any questions, Ms. Horn, from the board?
Yes,
Go ahead.
go ahead.
Okay. Ms. Horn, how long have you been doing this job?
I think 3 years. Don't hold me to that.
That's fine. And some of the paperwork said initially it was approved, then it was unapproved?
Yes, sir.
And what prompted the unapproval?
When I initially went out and viewed the right side of the home, when I pulled up, I saw the front of the left side as well as the front of the right. I got out of my truck, I went in the gate on the right side, I took pictures. It prompted me on my iPad, I went ahead and approved it. Got in it, was going to my truck and noticed that on the left side, they were not, both sides of the fence were not the same. So it drew my attention, went back out, I took pictures of the left side, and I corrected my report on site.
And the code shows for the finished side to be facing towards the neighbor, essentially.
The finished side on the right side appears to be correct. On the left side, it does not look the same as the right side. Yes,
Okay,
sir.
so this error in your judgment, you corrected yourself, no one brought it to your attention.
That is correct.
Thank you.
Mr. Schilling, any questions, Ms. Horn, based on that testimony? Okay, thank you. Any other questions, Ms.?
Yes, I guess if you came up from the other side of the house and saw, let's do what we did with the earlier, and let's mark these pictures, number 1 or number 2. The left exterior is number 1, and the left, or right exterior is number 2. Evidently, you came up and first saw the right exterior and saw that it was in compliance, in your opinion, and you approved it. But then when you saw the left exterior, different from the right exterior, you determined it wasn't in compliance.
Right, at first, it appeared that way. At second glance, when I looked over there, I realized that they were not.
They weren't the same.
Yes, sir.
Suppose you came up on the left exterior first, what would be your impression? Did you know enough about treated wood fences to know that that wasn't a finished product?
It didn't appear to be finished, no, sir.
Rather ambiguous, when you look at the definition of what a finished fence should be. I don't know,
I know a lot of time people double sheathe a fence. They double sheathe so that they meet the code for their neighbor, but they also get the look for theirself on their own property.
Yes, sir.
And,
That's allowed, right?
huh?
That's allowed?
Yeah,
Yeah, okay.
you double sheathe it. I don't wanna be the backside of the fence in my yard, so you double sheathe it. You just put wood on both sides. It's very
This is
appealing
board
to the
and battened.
neighbor.
So you see, the panels themselves are identical on either side of the fence. The only difference is the supports, the 4x4s, are exposed on one side and not exposed on the other. And I think they're determining that the exposed 4x4s should be on the outside of the fence opposed to the inside.
Well, a lot of people double sheathe them and you don't see the post.
Yeah,
Double
this is
sheathe
not the
both
case
sides.
here.
And how close is this to the property line? Can it be double sheathed? Can they do this, the outside just like the inside?
I don't think that's the question here. We're determining if
Well,
the
yeah, I mean-
ordinance was misinterpreted or not.
Right. I think I understand the point that's being discussed. However, what we're here for is to determine whether, in this board's opinion and based on the code, whether the decision that the left side, according to these pictures, is in
Where I'm
violation.
going with this is I read the very, very short, simple definition of the code. I've lost it already.
Hard to follow.
I had it highlighted so I wouldn't lose it. Do you have that handy, Mr. Eads?
On page 44 of the agenda packet, about midway down,
You would?
or-
Now, a one-line definition, fences shall be constructed so that the finished, in parentheses, sheathed side is oriented towards the adjoining lots. Finished, sheathed. With to me, a pretty treated board and batten fence such as this, I'd be hard pressed to tell you which is the finished side. If they did both,
It does say sheathed.
if they did both exteriors like the left, I wouldn't know the difference. I mean,
Take a look at this. See where it starts there?
yeah, there's a difference. Obviously, there is a difference in the construction style, but my concern is that either one, to me, is a finished look.
Well, Mr. Chairman, can we see if Mr. Schilling wants to put on any evidence? And then I think what we're talking about now would be appropriate, but it'd be more appropriate for during the deliberations after we hear all the evidence.
Okay, that's fine.
Or if you have any additional questions from staff at this point.
No, I just don't agree with the determination that it was not meeting the ordinance.
Mr. Schilling, would you like to present your appeal, sir?
I'm Andrew Schilling, 332 Northeast 41st Street. The determination that you've just made by reading that one line of the fence ordinance at 7.8.9, I believe it was, is that's kind of our issue as well. Essentially, after we went out, got the permit, built the fence, from our fence builder, that was his determination as well. We actually had two separate fence builders give us the same determination that since property lines were so close that you couldn't build the fence the same way on both sides. The side you're looking at here, that's a vinyl fence, and we were able to temporarily remove that because it just screws out and screws back in, and we had permission of the neighbor to do so. The other side where it was constructed on would be traditionally the reverse look. That was on a metal fence side, and you couldn't actually remove that, and our neighbor here is here today. We asked for permission at that time to remove the fence, but obviously we couldn't ask them to take their fence down so we can build a brand new fence on their property line. We thought by the language of the rule that it was left kind of open-ended, the way that is very loose language, one line, to help be able to, in these certain cases, build the fence in a finished manner on both sides. Like you said, if you drove up on one side, it would look finished. Same way on the other side. You wouldn't know that it was finished differently unless you looked at it from both sides. It's that we submit that the fence is finished on both sides. The language on the printout that we have does say, just want to add this as well, printout says sheathed, but on the website it does not say sheathed, it just says finished. And that's all I could see. My contractor actually had the form, it was taped up on our window. There it says finished and sheathed. And actually the planner and I have looked online and read what sheathed meant, just for the sake of argument, and it wasn't clear to us that it made any difference which side had the I don't know the language of the wood, but that board running across, the support board on the inside or the outside of the fence. So this was the way that we finished the fence was the best to our ability under the circumstance that we built the fence in, and we believe that it is finished on all sides.
Anything further, sir?
Nope.
Any questions?
No.
No cross from staff. Any questions from the board?
There is definitely, they definitely is a difference between the left side and the right side, correct?
That's correct, yep. And the reason why we allowed that to happen was two things. One, the constraints that we had on the property that only allowed us to build in a certain way. And then two, it didn't say in the rules that you couldn't build it differently, it just had to be finished. So by that language, we thought that we were,
Does this go across the back?
It does, yep.
Which side is the sheathing to on the back? I realize the left side.
We built the same way that you see on the right. all the way around to that edge where we could not remove the fence. And then that side, we did a different style.
You can see it in the middle picture. The middle
Yeah,
picture,
they-
Yeah,
Right,
the second
corner.
picture, you can actually see the,
the transition.
exactly, yeah.
If you got it correctly on the left side where you couldn't remove the fence, and you done it improper on the right side where you could remove the vinyl fence.
I'm sorry,
Am I looking at this correctly?
can you,
You done it correctly on the side you couldn't move the fence. And it's done incorrectly on the vinyl side fence where you could remove
so
it.
I think there's two, I take issue with that in two ways. One, the word correctly is what I'm appealing. That I feel like was not clearly stated in the rules. What is correct or not correct to us, I don't know the person on your left, but to his point, if you were to drive up from the other side of the road, you might think that side is correct. So what you consider correct is purely subjective.
No, I don't think it's subjective. I think it's a town ordinance. I think
that's where we-
seeing
that's
it for many years, why a lot of people, and here's the point, Brian, why a lot of people double sheave a fence is for the appearance for you and for your neighbor. Your neighbor, you have to give them the sheave side. You can also give yourself a sheave side. It takes more wood, and that's the point.
Yeah, I guess we, in the spirit of the rule, we built the fence as best as we could under the circumstances. We didn't realize that meant sheath or not. We were also told that we could add that piece of wood across this side, for instance, to mirror the other side to help stay in coordinates of to match that. As long as it all looked the same is what I was being told, that it would then be all considered the finished side.
I have a question for the appellant. I see that there is a white vinyl fence, and it's kind of the shorty one. What is that, 4 feet, 4 feet?
I believe I'm not sure exactly the height, but.
Okay, and then it gets higher towards the back?
Yep.
All right, so that's not offensive, hidden by that person's white fence, right?
That fence was able to be removed because it's vinyl. We
Yeah.
temporarily were able to take it down with permission of that neighbor.
Yeah.
Those screw right out and we screw them right back in.
Oh, I'm familiar with them. After a storm, you get to build them back up again. Yeah. It seems to me, the quick thing here is to do the vinyl all the way up to the front, but of course, that's extra expense.
It's also, that's personal preference on the style of fence, and then we get into what's no longer finished and what's the same and what's not.
Anyway, we're here today to affirm or deny the zoning technician's decision. That's the whole thing.
Anything else, sir?
No, just want to say we don't take issue with the way that she inspected. We're just kind of taking issue with the open-ended nature of the language. We would ask that something maybe clarify. As far as I understand, I just want to reiterate, the word sheath was not on the website version of this rule for whatever reason. It was on the print-off permit itself, and that's on me for not seeing that. But also sheath, to me, I mentioned take out the dictionary, we pulled that out, and I'm not a contractor, so I don't know the contracting language of sheath, but my contractor assured us that we were, in compliance by building it in the manner that we did.
Is your contractor here?
He's not.
And they've already heard it, but technically that would be hearsay.
Sure.
Because if your contractor was here, he'd be subject to cross-examination too. I was just trying to do my job here. You've heard it, but
You don't have to.
in a court of law, it would be hearsay. You've heard it, so I'm not going to ask you to ignore it. Go ahead, Mr. Sheldon.
Nope, that was it. So we just ask you that, we're just requesting that the rule be maybe clarified to say all sides should be identical or should look the same. if it's a finished side, that all sides should be identically finished and not just finished.
It's a text amendment. That would be a text amendment.
Yep.
I just have the dictionary definition of sheathing if they're interested as a board in to hearing what that is, since that's part of the applicant's contention. If the board would like to-
Would the board like to hear the,
This is the definition out of Webster's Encyclopedic Unabridged Dictionary of the English Language.
the definition, that particular dictionary applies to sheath or sheathing?
Sheathing.
Board like to hear that?
so-
Mr. Schilling, do you have any objections to that? Do you want to read it yourself first?
Yeah, I've read it before.
Okay,
Okay.
go ahead, Matt.
So sheathing there's several definitions. The act of a person who sheathes. Or number two, something that sheathes, covering or outer layer of metal, wood, or other material as one of the metal plates on a ship's bottom, the first covering of boards on a house, etc. And number three, material for forming any such covering.
Mr. Schilling, do you have anything you'd like to comment on the reading of that definition?
No, that's how we read it as well in the planner's office. We believe that, that wasn't clear enough to determine whether or not if this side was the finished and sheathed side or the other side was finished and sheathed. And that was our determination.
Did we enter that into the record, into the minutes?
It'll be entered into
I
the minutes. by the
understood that sheathing means the outer coating.
That's staff's reading as well. Especially the last part of the second, the first covering of boards on a house. So to us, you wouldn't, if you had a framed house, you would not
You
consider
don't
that
see the
sheathed
framing,
until it was
you just
covered.
see the outside layer of wood.
That's correct.
Schilling, you have any cross-examination questions of Mr. Kirkland, since he just read the definition and kind of gave a little additional testimony?
No, we just, based on that definition, we just believe that it wasn't, in the sake of the fence, in the building of a fence, we've seen it done both ways, finished before. We believe that, that's a subjective, what one side looks finished versus what the other side looks finished may just be totally up to whoever's, the eye of the beholder. And that's just the way that we've interpreted the rule. Contractors interpreted the rule and the way that it was built. And also just submit that we built the fence to the best of our ability to be able to, build along that fence line. We were told that we couldn't build it the other way, the reversed way, or the way that you see on the right side of the house because of its proximity to the neighbor's fence.
I believe you're gonna have to explain that one to me.
So because we're built on a slope, he has to stick build the fence board by board. From what I was told by our contractor as well, it's also hearsay, that and I've never built a fence before too, so I'm just going off of what contractors told us. It's not just him, actually, we had another contractor quote us the same thing. To build a fence this way, you have to have a clear opening to be able to construct the fence from the outside facing. To do the other side on the left, you can do that from the inside. And because we didn't have permission and the ability to build from on the other side of that fence, we weren't able to construct the fence the same way on all sides.
But I must have misunderstood you that you removed this vinyl fence.
Right, that's correct. We
can
were
we go-
able to
can we-
remove the vinyl fence and build it this way on the right side.
I'm sorry, Mr. Schilling, I just want to, maybe I can be of assistance.
Yep.
This is the right side, and you were able to remove the vinyl fence?
That's correct.
Correct? Now, if Mr. Kirkland will go to the left side, there's a chain link fence. Is that correct?
That's correct.
And your testimony was you could not remove the chain link fence.
That's right. You couldn't easily remove it and put it back like you could the vinyl.
On the vinyl, you just could unscrew and take out the panels, right?
Exactly. Our neighbor's actually here if you need to speak with her, but on this left side, we asked if there was, our contractors even a way to remove it and put it back. There would be no way to put that fence back the way it is now. So we'd just be asking the neighbors to remove their fence, and as new neighbors in the neighborhood, we couldn't do that. We figured building it this way is the best as we could do. Also, we thought at that time that building it, but based on that one line of the language, that we were able to do so based on the merits of the rule.
Mr. Thomas, does that answer your question, sir?
Yes.
Okay. Mr. Chairman, may I
Yes.
ask you if you'll flip back to the right? Okay. On the picture we're looking at now is the right side. Do you recall what the sequence of construction was from, with respect to right to left, front to back? I mean, did you start on the right
We
side?
did start on the right, well, so from what I've witnessed, the builder put the posts in first around the property, I believe he started on this side, because we actually didn't have a chance to get final approval from the neighbors on the left side. We wanted to build it first to see if we can get over there, and maybe by the time we're able to speak with them, we'd be able to, I don't know, potentially remove it, but then obviously, that wouldn't be a real fair question to ask anyway. So I think he may have started on this side, but I can't be too sure. I believe he may have started on this side.
Was the left side the last side to go in, if you know?
If you ask, it may have been.
Okay. But you're not for sure either way?
Yeah, I wasn't out there with him when he was putting up the boards. I believe it was, though. I believe it may have been.
Well, the left side was put in correctly, right?
Well, that's if you're asking me, that would be what I would, that's my contention, is that it's not incorrect. It's,
Determination is that this picture that's labeled the right, so if you're facing the house, this will be the right side of the house, where the vinyl fence is installed correctly. The left side, which is shown here, that faces the chain link fence, is installed incorrectly, per section 7.8.9 of the ordinance.
And Mr. Schilling, it's your position that, based on the actual language of the ordinance, you don't feel that that was sufficient to accurately describe either side of these fences as being the finished or sheathed side?
that's
is that
correct.
right?
We believe that both sides of the fence were finished. Based on that determination, we went ahead and built that way.
Any further questions or music?
Turn off.
Anything else, Mr. Schilling?
No, that's it.
Okay, thank you, sir.
Yep, thank you.
Does anyone else sworn in want to provide testimony here today?
It doesn't bother me with the way his fence looks. I'm the neighbor.
Okay, come on up, ma'am, if you don't mind.
Yeah.
I don't want the clerk to throw something at me. If you would identify yourself,
Cynthia Crowell, 334 Northeast 41st Street. I'm the neighbor that's on this side where the wood is on, facing me. It doesn't bother me at all. I'm the one that has a chain link fence that is cemented post in, and I've been there 31 years. That's why they couldn't. Trees have gotten bigger, and everything is why they could not pull my fence up to be able to put that in, or I wouldn't have had a problem if we'd been able to get it put back in. But I have pets, so I've got to have my fence. But I think the fence looks great. It's a very nice fence. It doesn't.
the side you're
That's my side, yes.
Right, but you think that side looks great?
It looks fine to me,
Okay.
yes, I see absolutely nothing wrong. I know the other side is different, but all the money that they spend and the way it looks like a nice fence. It doesn't, that one little section there that you can see, because the rest of it is all covered up by my fence. I don't think, to me, people's not paying attention to that when they're driving up and down the street. To see, you see the one side, yes, it looks nice, but I see nothing wrong with that side. At some point in time, I probably will put a privacy fence up, but not, like right now, anytime soon.
Any question? I'm sorry, could you give me your name again, ma'am?
Cindy, they call me Cindy.
Last name?
Crowell, Crowl.
Thank you, Ms. Crowell. Any questions, Ms. Crowell, from the board? All right, thank you, Ms. Crowell. Anybody else wish to provide testimony during this appeal hearing? Madam Clerk, let the record reflect no one indicates they want to. Mr. Chairman, unless there's any questions of either the appellant or staff or Ms. Crowell, I recommend we go to deliberations now, holding the evidentiary portion, holding until the conclusion. The issue before the board, if there's further questions, is what is the meaning or intent of section 7.89? And I'll read that verbatim into the record. Fences shall be constructed so that the finished, open parens, sheath, close parens, side is oriented toward adjoining lots or the public right-of-way. Staff has determined that the fence constructed on the left side of the property was constructed in violation. So the question is whether this board feels that that was an appropriate determination based on section 7.89 of the code. The only other evidence regarding code meaning was offered by way of a definition and the appellant stating that from his reading of it, as well as some conversations he had with contractors, that their understanding of this code section did not prohibit construction as depicted on the left side of the house, the fence on the left side of the house. It's the applicant's burden to prove that the board's determination was an error, and if a majority of this board finds that it was, you can reverse the decision. Majority of this board finds that it was not an error, you can uphold the decision. You are also, under North Carolina law, allowed to modify a decision. In this case, I personally don't see how you modify a decision, but perhaps there is a way you can modify it. So those are your options. I'll be happy to assist in any way I can.
Let me say, zoning technician Deborah Horn was correct, done what she should do, but then on the other hand, if the neighbor is not offended by it, and because it would be hard to put up with that fence, zoning technician 100% right. So she should have had that decision. But I'm saying, with that said, if the neighbor's not offended, the way the fence is oriented to her, she's right, but can we say, well, if the neighbor's not offended, then let's leave it be?
That's a direct question. I'm gonna give you a direct
Yeah.
answer, no. However, that's more of a variance type consideration, and we're here on appeal, not a variance. You can, based on the neighbor's testimony and lack of objection, consider that as to whether an average person would consider this side of the fence being finished. I think she said it looks nice, if I'm not mistaken. But the technical answer and direct answer to your question, can you consider the fact that she does not object as a grounds? No. You can consider her visual observation and opinion and compare that to the language of the ordinance.
Accepting it as an alternative to the ordinance would, you're right, be more of a variance issue than it would be an appeal. I'm leaning towards the interpretation of the ordinance itself. It's not really clear. To me, that's a nice fence. Maybe not quite as nice as the other side, but it's not a bad fence at all. I'd be hard pressed to determine that that wasn't the finished side of a fence. So I'm thinking that the language of the ordinance itself wasn't clear enough to warrant a decision to reject it. That's where I'm going with it.
Looking at the left side, I wouldn't want that next to me, or if I liked it okay, I wouldn't protest. But if you're asking me to say, did she interpret wrong? No, she didn't interpret wrong. She interpreted correctly.
I'm with Ken on that, that is correct.
Now,
Unfortunate, but correct.
she done it, she was 100% right.
Oh,
Now,
yeah, I agree
now
with
there's
that.
some way that we can fix it,
She was
and the
right.
neighbor's okay with it. Make Steve get up here, he's done this long enough.
She was right in her interpretation. I believe the builder was right in his misinterpretation and thought that what he was doing was within the ordinance.
Now, the builder didn't
That's
misinterpret.
the heart of the issue. If it can be if you find that it can be interpreted in two different ways, i.e. that the ordinance language would lead a reasonable person, or more than one reasonable person, to interpret it two different ways, then in that event, you could reverse the decision. But if, like someone had mentioned, we'd have to, or staff would recommend a text amendment. So you can't split this baby.
Wouldn't necessarily warrant a text amendment. It could be a case-by-case situation. If it cropped up again, then it'd come here again.
Well, that's a good point. I mean, I've seen fences where one side is a flat side and the other side's got all kinds of support webbing,
Yeah.
which is not as, I don't want to weigh in on this personally. It's not the same look as what we're seeing here on the screen, so.
I'm looking at the ordinance the way it's written and what they had to work with, that they did the best they could to make it look like a finished fence and the constraints they had to work with.
You have three options. The way you rule on one of those three options is by motion and vote, so.
We ready for a motion yet?
Go ahead.
Told us we couldn't. Because I don't want, if we say, well, any reasonable person could make a mistake or whatever, I don't want to set a precedent then where the next one can do it, the next one can do it. You follow me?
Yeah. And this ain't a reasonable person, this is an inspector.
Yep,
Follow
and
the
she ruled
rules.
correctly.
Yeah.
And if I was on the house on the left, thank you for ruling the way you did, okay?
So what's your motion?
The ordinance still has to be, I just want to make it clear, the ordinance, that's why the appeal process exists. The ordinance still has to be clear or unambiguous. And I'm not saying that it is or isn't.
It is to me. She, they have another remedy, is what I'm asking you, Brian, needs, that they can bring back or do, and let it be suspended in the meantime?
Well,
It would have to
This-
make it more lax.
we just conducted an appeal hearing. So another alternative to an appeal would be a variance, but implicit in a variance is that the call on the code was correct, because you're asking to vary from that. So as far as today's options, it's reverse, affirm, modify. I can't speak for staff. I don't know if there's, perhaps we could recess for a moment and let staff and the appellant talk and see if there's,
I'm not sure what discussion there would be. The staff's made a determination that this fence does not comply with the code. And at this point, it's at the board's determination. Any other application outside of that is moot to your determination as to whether staff, based on the plain language of the ordinance, that this side on the left side is not, the sheathed side is not oriented towards the adjoining lot. And so that we cannot pass an inspection on it. We don't have a open code case to my knowledge. The only thing that's being held up in this instance is they have a permit that cannot be finalized and inspected based on the way it's constructed right now.
So would this violation have been issued if all of the outside looked the same?
I can't speak to the staff determination on that, but I can say that based on my interpretation of the ordinance, that this is not a sheathed side of a fence. And that per the ordinance, the plain language of the ordinance, the sheathed side has to face the adjoining lots.
There's no way to build it the way that's constructed. Because
I don't see any wiggle room. I'm ready to make a motion to affirm the technician's decision.
Is that a motion?
That's a motion.
I second it.
Yeah. Motion and a second. All in favor to affirm the decision?
aye.
Unanimous. The only recourse here, I think, would be a variance.
Or a text
I
amendment
don't see
to.
it meeting variances on the hardships.
Well, that's not, we haven't,
Yeah.
Yeah,
that's
those
right.
are-
Oh, yeah, we
Yeah,
can't
please don't
discuss
discuss
that
that
at this point.
unless you get an application in front
I
of you.
I tell you, you know, though, staff could talk to, the fence could be modified. I'm not a carpenter or a fence contractor, so there may be some alternatives to,
I'm not either.
so, but
Great
that,
questions.
I'll leave that between staff and Mr. Schilling. At this point, the motion's been unanimous to affirm the finding that this left side construction is in violation of that section of the code that I read earlier,
7.9.
7.8.9, in that left side construction does not reflect the finished sheathed side of the fence facing the adjoining property. Staff and I will draft an order, get that to you, Mr. Chairman, for signature, then we'll serve that on Mr. Schilling. Mr. Schilling, I am not your attorney, so I can't give you legal advice, but there are certain appellate rights beyond this board if you're dissatisfied with the decision. And thank you for your time and presentation today, sir.
Still think the ordinance needs a little attention.
I do too.
Yeah, but
Close the evidentiary portion.
All right,
Oh, we need a
motion
motion
to
to close.
close.
Close, yes, sir.
second.
All in favor? Closed.
Is there any, I don't have the
folks.
agenda. Anything else?
I don't want that turned to me.
Staff reports, which we have none, unless Lisa has one.
I believe the only other items on the agenda are staff reports. Ms. Stites, do you have any? Because Matt does not have any.
Those are
Motion to adjourn would be in order unless,
Motion?
Second.
Second. All in favor?
Aye.
Adjourned?
The last meeting, I gave you credit because you just closed the meeting, and I figured that's the way we did. Is there any more business? No, hearing none, we're adjourned.
I just don't want to say that's okay. Enjoy it.
No, really.
Ray,
Here's one of your pens back.
here's another pen for you.
You have a signed copy for me?
Ray, you need to sign the paper.